Yes, sir.
I am somewhat hearing impaired. Does the voices carry well here? I wear hearing aids.
Yeah, they carry very well. We have another attorney who has hearing aids that doesn't seem to have it.
Okay. Because I was in Tallahassee last Wednesday, and I forgot to tell the marshal that my hearing is impaired. And Justice Groshands and Justice Sasso, you know, like women, as opposed to Kennedy was bellowing and some of the other ones.
Yeah.
And I had a little trouble hearing, so I usually, when I get into a hearing, I usually make that declaration. Because sometimes, you know, if I don't hear what he said, you take it as disrespect, or you're not responding. That didn't ever intend that.
It does carry pretty well.
Okay. Thank you. Appreciate it.
No problem.
No, I never appeared. No, I never did any cases in there. Did what? A lot of ADA. Yeah. No, I had a lot of cases, which I've heard. Just to remind you, John, you're on live streaming in here. Conversations.
We're talking right now. You didn't get that.
Well, not very clearly, but it can be.
Okay, all right, let's see.
Just let you.
But it's a lot of courtrooms that way. You can serve courts time. There's a lot of that. Thank you. Yeah, I was trying to taste it. You know, I was trying to see if I can hear some. I came down in the lunchroom of the courthouse. I see some judges on that. And so what's going on? So I'm trying to get, there's so far. I said, we've been watching this. Who is the audience?
So let's step outside of this so we can be live streamed. All the way.
Good morning.
Sorry. I'm sorry. You're going to share it. Can I get counsel? You had to do the work.
That's good. I came on yesterday afternoon, and miraculously, Disney from downtown was heavy, but it moved.
I do a pretty good job all the way downtown on that, but there's two passes that you can do.
417 is one of them?
417, right, but the other way.
Okay.
Yeah, my way, you have straight through that, and it's a couple of holes, but you avoid both traffic.
I'm gonna check the ways.
Because I hate driving through Atlanta.
I've been successful with Tallahassee, Jackson, Fort Lauderdale, Palm Beach, now here, down to Lauderdale, Palm Beach. It's like traffic,
My roommate's wife is an attorney, and she lives in Palm Beach, so if I ever have anything I need to her done, I just send her in. So it saves me all the travel. Yep. Yeah, I wouldn't want to travel as much as you say you're traveling. I try to stay in Volusia County, Seminole County, Flagler County.
So you get over to the land courthouse for that, right?
I'm in the city of
But the land is in Volusia County, right?
It is.
I know it's part of your service.
It's actually where the big courthouse is.
Yes. I couldn't believe
And
that.
actually, when Barry and I were first starting out, it was an old courthouse building we died. It had no air conditioning. And I tried to, when I was secretary with Jim Smith, we tried to case it.
It's still old, but it's there.
It's a historic building, because they had certain sections set aside for different classes of people, in the Concord building. It was really a nice courthouse. You walk around the floor suite. Felt pretty good.
You want to check my.
I have nothing in this quarter. It's like today, I have another deal coming up. That's just, that's what my hours on later. It's like, that's my key case of ice cream.
All rise. Court of Appeal in the Fourth and Fifth District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons have business before the court around here. Give attention, you will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
Good morning, everybody. I've been introduced. I'm Judge Jim Edwards. To my right is Judge Brian Lambert, and to my left is Judge Harvey J. We have one case here today, and today is Wednesday, June 11, 2025. The case we have is case number 242303, Charles D. Ogden versus Sharon D. Felice. And we're here with regard to the court's sua sponte order to impose sanctions. And the purpose of this hearing is to give Mr. Haar and his attorneys the opportunity to explain to us why sanctions should not be imposed. So we have folks sitting in the audience. If you, is Mr. Haar one of you?
Most nervous-looking person in the room, I assure you, Chief Judge.
All right. Well, if counsel, and I'm not,
Yes, my name's Barry Hughes, I'm the attorney.
all right, yes, Mr. Hughes. If you want to sit at council table, you're welcome, and yes, sir.
You have to stay back.
Okay, that's fine.
Your Honor, my name is Scott Tosian.
Okay.
I represent Mr. Hart.
Well, if y'all would like to come on up here and you can have a seat at council table, that's fine. And Mr. Hughes, you're perfectly welcome to sit right where you are, that's fine. And I guess, Mr. Haar, actually, before you sit down, if you'll raise your right hand, do you swear or affirm that any testimony you give here will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, great. Thank you very much.
Judge Edwards, how would you like to proceed?
I'm going to let you know.
Okay, all right, thank you.
Fair question, but So the reason we're here is the court has determined that Mr. Haar pursued a frivolous appeal by filing frivolous briefs, and that was set forth in our April 25th order. We gave Mr. Haar a chance to explain to us why sanctions should not be imposed, and he filed a written pleading which did not clear things up for the court. So I'm going to have some real short yes and no things for you, and if we can speed things along or we can go through things. If y'all agree that the appeal was frivolous, then we can cut on over to the other part. If you cannot say yes, we agree it's frivolous, then I'm going to lay out why the court thinks it was. So go ahead right now. You can tell me. Does Mr. Haar agree that it was frivolous?
We absolutely agree that it was frivolous, yes.
Okay.
And he's prepared a statement after your questioning that he'd like to make to you in acknowledgement of that fact and what he's done since he received the most recent order to try to address the shortcomings that you see in the filing being made in this case.
Okay, great.
And at the end, I'd like to address it more briefly.
Well, I certainly anticipate giving you plenty of time to address the court and to have your client's statement. So basically, I'll keep it very short then. Basically, what we had here was a civil suit in which there was a kitchen remodel job. Plaintiffs sued Charles D. Ogden, doing business as one business. Mr. Ogden's first lawyer said, no, that's the wrong business. You need to amend the complaint. They did and changed to the name that the Ogden's first lawyer said. Went through trial with Mr. Ogden at trial. Final judgment was entered in favor of the plaintiff and against Charles D. Ogden, doing business as apparently the correct name. The time for appeal passed with no appeal, and then Mr. Haar filed a motion to set aside the final judgment based on the fact or the claim that the wrong defendant had been sued, that there were issues with service of process, issues with jurisdiction, and issues with piercing the corporate veil. The trial judge denied those. Mr. Haar then, on behalf of his client, filed an appeal to this court, which basically raised those same issues all over again. We found in favor of the appellee and affirmed the trial court's order. When we set out the April 25th order, the response we got from Mr. Haar was essentially a re-argument of those same issues that had been raised below and raised on appeal, and we found that insufficient. And at this point, we are certainly contemplating imposing some sort of sanctions because there was no support in fact or law on this appeal. We don't deal with what happened at the trial court. That's up to the trial judge, and we're not considering any sanctions or measuring our sanctions in any way based on what happened at the trial court, because that's not up to us. That's not our bailiwick. But certainly, this is an unusual case. We don't do this every day, and we take no joy in doing this. But we are duty bound by the canons of judicial conduct that if we see something inappropriate at a certain level, we do have to take appropriate steps, and that's what we're doing here now. So with that, if Mr. Haar wants to make his statement now, or Mr. Tozian, if you want to make a statement now, but...
He'll make his statement now, after which I'll
Okay.
briefly address it.
Thank you. Yes, please come up to the podium. That way we can all hear you clearly.
I apologize ahead of time. I'm shaking. I'm nervous.
Well, I understand, and take a deep breath, and if you need a glass of water, by all means, get a glass of water.
Thank you, Your Honor. Thank you for the opportunity to appear in person, to apologize to this court for an appeal I never should have filed. I sincerely apologize to this court and to opposing counsel, Barry Hughes and his client, for having to defend this appeal. It's an appeal that I should not have pursued. I've also apologized to my client and offered to refund all of his attorney's fees. I exercised extremely poor judgment in this case, which is my fault. Although I represent Mr. Ogden on other matters, my involvement in this case was not until 4 months after final judgment was entered against him. I wasn't his lawyer at the trial. He went without a lawyer. When I met with Mr. Ogden, he was adamant. I was listening to his contentions rather than focusing on my careful obligation to review the facts and the pleadings. I should have focused on the details, especially the admissions that was in the answer, which said that Mr. Ogden entered into a contract with both Alfred and Sharon DeFelice. When I read the court's opinion affirming it, I was shaken. I have had other cases here. I've had oral argument in front of Judge Orfinger. When I filed the response to the court's order to show cause, I put myself in defensive mode, which was clearly not what this court wanted. I tried to do what I thought the court wanted me to do, and I was mistaken. Once again, my fault. I tried to explain my flawed thinking and defend my actions, then objectively view the facts. And when the court found that my response was insufficient, I was shaken, I was humbled, and more than anything, I knew it was time to reach out for help. I hired counsel, who's here with me. I consulted with a former 5th DCA judge, and I've spoken to a couple attorneys in this community who I hold in high regard. I've taken CLEs, which Mr. Tozien will talk about, in both appellate practice and ethics, to make myself a better person. I spent hours, Your Honors, I have beaten myself up since your opinion originally came out.
Let me ask, when you say opinion, I mean, you're talking about the order that set this, or it was just a PCA, wasn't it?
No,
it was a written opinion.
Was it? Okay, my apologies. I went on the original panel. Sorry.
I have beaten myself up, lost so much sleep over this, renewing and reflecting every single day, 7 days a week, on the things that I did wrong. And with that, I accept responsibility for my mistakes. And I assure this court, it will not happen again. My conduct in this case did not reflect the respect that I have for the legal profession, which I hold on the highest pedestal. It is a privilege to practice law. And even more, the way we respond to orders from judges. I'm profoundly sorry for wasting this court's time. I'm profoundly sorry that we have to meet here today. And I apologize.
Well, thank you very much. Thank you very much. Certainly not our intention. I understand your anxiety and nervousness and all the rest that you described. That's never our intention to visit that upon anybody. But again, we're duty bound to deal with situations like that, and that's what we're trying to do here. And I appreciate your taking responsibility for it so fully.
It's genuine. It's from the heart.
I have no doubt. Counsel?
Yeah, if may it please the court, just by way of introduction, again, my name's Scott Tozien. I practice in Tampa, and I worked for the Office of the Florida Bar in Ethics and Discipline, both as a law clerk in 76, 77, 78, and then as a lawyer in Miami and Tampa in 78, 79, 80, and into 81. My practice has been devoted to representing lawyers, applicants to the bar, and judges in JQC proceedings, almost exclusively now for the past 20 years, but the lawyer and the bar examiner part for over 40 years. Mr. Harf stands before you as a 25-year member of the Florida Bar who's never been disciplined, never been held in contempt, never had sanctions ordered against him. In the last week, in order to address the court's concerns, he took a number of CLE courses, and I have for the court copies of the certificates of completion. I think there were 7 different courses that he took. Most notably, there were 2 involving appeals, the filing of briefs and the handling of appeals, and one was the Masters of Ethics. And there are others, and you can see if the can I provide these to the court?
Yes, you can, our bailiff can, our marshal.
Thank you, sir.
And we may ask you to file them as well.
If you would, please. Yes, Judge. So, clearly, this matter was mishandled. I mean, there's no doubt about that. He relied on a client of long-standing insistence that, he had been wrongfully, had a judgment entered against him, instead of carefully reviewing the file before and seeing the very things that the court saw in affirming the judge's judgment. He didn't read the answer where in 4, 5, and 7, he entered into the contract, he accepted the money, and he started the work. I mean, game, set, and match. And then he doubled down in using bad judgment when he responded to the show cause order, where he continued to defend his actions. And I'll tell you from what I've done for a living, that's far more common than you would think. Until even well-meaning, intelligent people, until they get advice, they violate the first rule of holes. When you're in one, quit digging. And many, many, many of my clients keep digging. I don't want to waste too much of your time, but I had a bar applicant from Ohio. He'd been a lawyer there for 7 or 8 years. He left 4 arrests off his application for admission to the Florida Bar. 4 misdemeanors, not involving drugs or alcohol. Clearly he would remember them, and he left them all off the Florida Bar application. Bar examiners, by the way, are very, very efficient. There's no getting anything by them. And they found them, and they wrote him a letter in Ohio and said, please explain if you were arrested these 4 times. If so, why wasn't it on your application? He says, yes, it's true, and I forgot about those 4 arrests. So he came to see me, and he says, what do we do? I said, well, the first thing we do is we write to the bar examiners. We tell them you lied. And he said, well, I can't do that. And I said, well, why not? You did lie, didn't you? And he said, yeah, but if I tell them I lied, they'll never let me in. And I said, no, they already know you lied. If you don't tell them you lied, they'll never let you in. And his statement, this has lived with me for 15 years, he said, that's counterintuitive. And that really explains how lawyers, keep avoiding what should be obviously inevitable, and that is you didn't handle this correctly. You need to acknowledge that. So that's why I share that story with you, because he was a lawyer up in Ohio, and he didn't have any problems either. He just wanted to get in quickly without answering.
Did he get admitted here?
I'm sorry?
Did he get admitted into Florida?
He did. We did some community service hours, and they let him in. And I think the takeaway is it's not always easy to know the right thing to do. Once you know the right thing to do, it really is pretty easy, and that comes from hiring a lawyer. So again, he took these 7 courses that we referred to. As he said, he offered the feedback to his client in full. The client declined it, just so you know, because he owes him additional funds for other cases, so the client did not want it back, but ostensibly will want credit for the money that was paid. I would like to propose that the court do something other than fine sanctions, and I'll tell you what my rationale is for that. Mr. Harr is perfectly willing to go to your local legal aid society here and do 50 hours or 100 hours of legal aid work, something that's corrective as opposed to punishment. And I'm not saying that the punishment wouldn't be deserved if you entered sanctions. But what I will tell you is that in December of 21, the Florida Bar adopted a rule whereby judicial referrals to the Florida Bar are given heightened scrutiny. And I don't know if this court's aware of that, but if a grievance committee does anything other than find probable cause, it's first referred to the Board of Governors of the Florida Bar for approval. And if the Board of Governors approves, it goes straight to the Florida Supreme Court for approval. Because this is what I do for a living, we've had several cases that were kicked back after a committee tried to do something other than, or tried to find no probable cause. And even diversion, we've had diversion recommendations kicked back. And what happens is, and if you think that's appropriate that it go to the bar, of course, I mean, that's what you need to do. But it takes on a life of its own. It gets heightened scrutiny, like I said, and the bar feels an obligation. And this all started when Michelle Suskauer got in trouble down in South Florida. She was the president of the bar, and she took a disbarred lawyer with her to federal court. And the federal judge recognized that it was a disbarred lawyer, and he knew there was Rule 3-6.1, which says that there are very strict circumstances under which you can hire a suspended or disbarred lawyer. And he referred her to the bar, and the bar referred her to diversion, which, according to what you hear, the scuttlebutt, is that made the federal judge extremely unhappy. So that's what spawned the rule. But as you can guess, when a court order ends up being a grievance, it takes on a life of its own. And I have a case now in South Florida. My client missed a sentencing in federal court, and the judge, whose name escapes me because I'm getting old and having trouble with names, but a very fair guy by all accounts, referred her to an ad hoc grievance committee, federal grievance committee, and they took action and said, a moratorium on taking new cases for 6 months, get a mentor, and take some CLE classes. And that's the action they recommended, and that's what Chief Judge Altanaga ordered to be done. Well, the bar got a hold of it, and they said, well, she was suspended for 6 months, so we're seeking reciprocal discipline of 6-month suspension. Well, she wasn't suspended. There was a moratorium on new cases. So I was in Palm Beach recently trying that case, and eventually we had to get something from the clerk saying she was not, because the bar was wanting a 6-month suspension from the bar. The takeaway, of course, is that my client has spent a lot of money defending that case, and it's not over yet. But I think we're not getting reciprocal 6 months because it was not a 6-month suspension. But judicial complaints really get a lot of traction, and they take a long time to resolve, and the bar feels pressure to pursue them. And again, I'm not saying that's a reason not to do what you're contemplating doing, is that that's what you think is appropriate, that's what needs to be done. But I just want you to be aware of the implications of that. If there's something we can do, correctively, if you will, and for him to express his contrition and to show what type of character he has by doing pro bono work, deferring on the issue of sanctions, coming back to you in 2 months, 3 months, 6 months if you wish. If you can indicate what you think would be appropriate, something along those lines, that's what we're asking you to do, is to not find sanctions and to find some other way where you're comfortable that this behavior will not be repeated and that the message has gotten through to him.
All right. Thank you very much. I don't know if my colleagues have any questions at this time. Mr. Hughes, do you have any comments you want to share with the court? If you do, please approach, and if you go to the podium.
Should I be sworn?
Are you going to give us any factual information?
I think just to be safe, I'll be sworn.
Raise your right hand, state your name.
Barry Hughes.
Right. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Yes, and I'm going to be very brief. I didn't intend on speaking today, but I've known Jason for years. I've been practicing law in Volusia County, Florida since 1983, and I've known Jason probably about 2 decades now. And we've litigated cases against one another, and we've always treated each other professionally. I always thought that he was competent. I think he was a little bit out of character in this particular case, but my experience with him is that he's always been a forthright, hard litigator, and generally the practice, we're a nice community here, I think. And when one attorney tells me they're going to do something or something, sometimes we extend those courtesies, and it saves some of the expensive formalities of discovery and so on. And I've always had that relationship with Jason, that if, we try to expedite things, try and, cooperate with one another with regard to discovery so we can get our matters to trial efficiently with not a whole lot of cost or minimizing the cost of clients. Litigation is always expensive. But my dealings with him has always been professional. Now, with regard to this particular appeal, I agree that it was a frivolous appeal. It was over a $10,000 dispute over countertops, which, could have obviously been resolved, probably spent more money in attorney's fees on the appeal than the judgment was worth. Notwithstanding that, I believe the court wanted to get Mr. Haar's attention on filing this appeal. And I believe that, and I might be wrong on this, I don't pretend to be an expert, but the purpose of the court and the purpose of the bar and sanctions is to deter future actions, the future type actions that resulted us in being here today. Now, listening to Jason today, listening to counsel today, having received an apology from Mr. Haar, I believe he's got the message that he needs to be a little bit more responsible to the courts and to the opposing side, as opposed to just, digging in and taking what his client wants to do. There's cases we should take, there's cases we shouldn't take. I think he's got that lesson. So I concur with counsel for Mr. Haar on relief. I personally don't believe sanctions are appropriate in this case. I think he filed
Let me ask you, counsel.
Yes, sir.
As the appeal was going on, did you talk to Mr. Haar and say, for lack of a better term, what are you doing? Why are we doing this?
Yeah, and he would explain it to me, and he would go into lengthy conversations with me, and I basically said, I don't see your appeal at all.
You were the attorney for the plaintiff at trial, weren't you?
That is correct.
Okay, so
I don't do many appeals. You haven't seen me here in probably 20 or 30 years.
no, but I get my
Which would count us out, so.
What?
My point being, though, is you were able to say, well, your client admitted that he was the defendant and he got the money and he showed up at trial. So, Mr. Haar, or Jason, what are we doing here? We can't have people come in after the trial and say, oh, by the way, I know I just lost, but it ain't me. We'll have a do-over,
He believed that the son was the proper defendant. I disagree wholly.
Well, I mean, but...
And the trial court just disagreed also.
Well, I get all that, but I mean, he comes in after Mr. Haar comes in after the fact when Mr. Ogden has already acknowledged that he's the defendant, he's litigating, he's not telling anybody that he's not the right defendant, and that kind of ends the discussion for the point of the appeal, and you being friends with him, and I'm not saying you're close friends, I'm saying, what are you doing? Why are you appealing this? He was there and he said
I thought the case could have been resolved for just paying the judgment less expensively. Just honestly, it's not a lot in dispute. So I thought we should just settle it. But I can't get into settlement discussions.
What do you mean you can't get into discussions with
Because
him?
I believe they're
Settlement
confidential.
discussion.
Yeah, they're confidential.
No,
I don't do a lot of appellate work. I do a lot of trial work.
I'm not talking about settlement, I'm just kind of yeah. It strikes me that this is fundamentally frivolous, and you would have pointed out, hey, I don't know what your client's telling you, Jason, but that you're barking up the wrong tree here. It's all done. I mean, to say it's a void judgment when the guy didn't contest that he was served or anything of that nature seems, well, I mean,
Yeah,
it's found frivolous. And so
I went through great efforts having him served and identifying him, and so I agree. But I think Jason's got his message, is what I'm here to say.
Better late than never, apparently. Well,
It's a-
his
it's a-
counsel apparently is impressed upon him that perhaps this is the better route to take, and I wholeheartedly agree with his counsel.
I agree with
I appreciate you sharing your thoughts with us. That's,
Okay. Thank you, Your Honor.
Make just one further point. I really believe that the key for people is hiring a lawyer. I mean, I really do. And just to put a finer point on that, I had a grievance initiated against me about 5 or 6 years ago by a bar prosecutor who, for reasons we don't need to discuss, didn't particularly care for me. And our firm's the biggest firm in Florida that does what we do. So I have partners that are, skilled in this area. I wouldn't have represented myself, even though I thought the complaint was baloney. I wouldn't have asked one of my partners to do it because they're too close to it. So even though I knew it was not going anywhere, I hired Hank Cox from Jacksonville, ex-bar president, and Warren Lindsay, a lawyer from Orlando with extensive experience in this area, to represent me, and they got it closed out. But if people who do it for a living wouldn't dream of representing themselves, it really compounds the situation when somebody who doesn't know the lay of the land to try to represent themselves. So I know that it is late, but a lot of times it has to come from an independent source for people to understand, what the process is about and what the peril is and what's expected of you. So, and again, he's never been in trouble before, and I would submit to you that it's not likely to occur again if he's got 25 years of an unblemished record. So I appreciate the extra 2 minutes.
Well, I have to say that when I was reading the case, I wanted to see who it was, quite frankly, that filed these briefs under these circumstances. And when I saw Mr. Harr's name, we don't know each other, but I certainly know the name, and I was caught off guard that was who had filed these briefs. So to the extent you're talking about, I didn't look into whether he'd been into trouble before in terms of the briefing and all the rest of that, but I think we've had briefs from him before in this court, in cases before in this court, and like I said, it took me a bit by surprise that that's who had filed these briefs, because quite frankly, I've seen people make iffy arguments before, but this was certainly among a very rare few, and so again, we do not like to have to engage in these things. We're duty bound to engage in these things. It certainly seems to have gotten Mr. Harr's attention and turned him in the right direction, hopefully. And I don't know if my colleagues have any other questions or remarks, but we will certainly confer among ourselves and reach a decision. But
Nothing further.
okay, with that then, we will adjourn and we will send along a written order or a written opinion with our decision. And I appreciate everybody being here, and I appreciate the candor with which everybody's dealt with the court at this point.
Judge.
All right. We're going to be in recess. Thank you very much.
Thank you for your time and attention. Thank you, Mr. Stoltz. Thank you.